I just saw what the court just did. So I just think there's been a sea change in how it's done, and they have the votes. And apparently, Roberts doesn't give a damn about institutionalism anymore.
It's the Lawfare podcast, Trump's Trials and Tribulations. I'm Benjamin Wittes, Lawfare's Editor-in-Chief, here with Anna Bower, Lawfare Legal Fellow and Courts Correspondent, and Lawfare Senior Editor Roger Parloff.
I actually think that this is among one of the better briefs that I've read from Trump's New York trial team. What they've done here is take the gift that the Supreme Court gave them, and it says, I think, a lot about the Supreme Court's opinion in that they are able to stretch it to the extent that they have in this brief.
In a live recording on July 18th, we talked about Judge Cannon's order granting former President Trump's motion to dismiss the classified documents indictment. We talked at length about Trump's motion to vacate the New York verdict under the Supreme Court's immunity decision. And of course, we took audience questions, including about what the heck a writ of mandamus really is.
I think with all of these cases, what we have to do is try to figure out what Justice Roberts is concerned about, and it's not easy.
Hey folks, Ben Wittes here in the Hammock Studio, and welcome to this week's Trump's Trials and Tribulations. I am joined from the Mar-a-Lago bathroom by Anna Bower, and from the Jura studio, the last day of his 2024 summer French sojourn, Roger Parloff, ready to begin the big trek back to Washington, D.C. Welcome to you both. And before we dive in on the beginning of the fallout of Trump v. United States for the case in New York, Roger, you were at dinner at the time of our live stream the other day on Judge Cannon's ruling dismissing the Mar-a-Lago case. And so I want to start with your thoughts and reactions to that. The floor is yours. What'd you make of it?
Well, as you know, all of us, by the time it came out, were not surprised. And I had seen it looming on the horizon and getting worse and worse. And I have no confidence that this won't be upheld by the Supreme Court. I think it could well be. That means I don't know what will happen at the 11th Circuit, but I don't think you need a circuit split on this one. I think it's going up. And that means it's not a great vehicle for asking for reassignment. I think there might be one exception about that. But the main thing is, it may not be the most gracefully written opinion, but it holds together generally. There are strong parts, there are weak parts. But the best thing that the special counsel has had going for it is historical precedent, meaning a lot of this has happened and a lot of it has been accepted. And the current court doesn't give that a lot of weight. And I do think the case that the Supreme Court's ruling in 1974 on the relevant questions about whether there's a statute that authorizes his appointment, the notion that that's dictum, I think that's a colorable case. It definitely wasn't argued, which is significant. There's a case that it was necessary to the ruling, but and in fact, I think she's right that the judge in the Manafort case, or one of the Manafort cases, T.J. Ellis, who's a legitimate judge in the Eastern District of Virginia, also found in a slightly different context, that the U.S. Supreme Court ruling was dictum. And she correctly quotes that, something like Nixon is inapposite in as much as the holding there did not adjudicate the legal authority of special counsel. And I think this, the place where if she's wrong, it would be about a statute, 18 U.S.C. 533. But I think the main thing is that so much has changed since these rules, since the Nixon case. In Nixon, there was a lot of consensus. There was a lot of consensus for many years that to begin with, that that no man is above the law, and that's now in the toilet. And there was also this understanding that it was a bad thing for the president to be a criminal. I don't know if that's still a consensus. And there was this view that if you're going to investigate a president, it makes sense that the investigator shouldn't be the president's attorney general. All of that is no longer accepted. And so I don't know that this won't be upheld. So I think it's not a great vehicle to get her reassigned. And then the only exception, the only hesitation I have there is what she did relating to remedy. And here again, though it's a weak situation, the special counsel did this weird thing, as they often did. They were not flawless in their opposition. They chose not to address remedy. They said, look, we have authority. We're not bothering to address remedy. That's not, the way you do it. And then apparently at the hearing itself, they realized, oh, she's really taking this seriously. And they said, okay, if you're taking this seriously, it behooves you to, we ought to have more briefing. And at that point, for the first time in 2 years, of handling this thing, she says, no, too late, no more briefing. This person who just lived for briefing, I'll have hearings on a motion for a bill of particulars. I'll have a hearing on a motion for, dismissal based on duplicitousness of, in the indictment, all of these arcane stuff. And so she refuses to get briefing and dismisses it the morning of the Republican National Convention. That looks bad. And if they want to both appeal this case and lay out what's been going on in other matters, maybe they'll take that approach. But like I say, if she's going to be upheld, which I think is very possible, it's a tough call.
All right, I want to be the little ray of sunshine here and say I don't believe there are 5 votes for this proposition. And we have 2 statutes that say that the Attorney General can kind of appoint people as needed. I don't have them in front of me, but neither of them is especially subtle. And since this really comes down less to the Calabrese question of whether he's an inferior officer or a principal officer, and more to the question of does the Attorney General have the authority to appoint him under the statutes, I guess I want to know why you think there is, in the face of all this practice, and without resorting, as she did, to 93 pages of mumbo jumbo, a lot of which is not relevant to the question. And we know there's 1 vote for this idea. But why do you think there are 5 votes for the idea that the Attorney General of the United States lacks statutory authority to appoint a special prosecutor?
Because back then, as most of these cases that have upheld it had this view, everyone sort of agreed this was a good idea. And then you have these general statutes, and they're not appointing somebody to do this. They're not creating an office to do this, but they give the attorney general authority to do this sort of thing. And so let's let it go. And in fact, one of the important—
Hang on, though.
No, wait. The first DC Circuit ruling in resealed case. So that's the one that lets Lawrence Walsh says that he's okay. That's the Iran-Contra guy. He says something to the effect that the panel says Congress didn't explicitly appoint, create a special counsel, but the statutes can accommodate it, and that was how things were done. And then people like where it begins, I'm not. It could be Buckley versus Vallejo. It could be, Steve Calabrese. I don't know when he makes this up, but maybe it was Scalia. But everyone begins looking for more than a mushy thing. They say, no, it has to be a statute that appoints this or creates this office. And there isn't one of those. And the best one, which is 533, it's true. It's stuck in a statute, in a statute that is really talking about the FBI. And ordinarily that doesn't matter. It's not where the title is. But if you're a right winger, I just saw what the court just did. I have no confidence that they will not say, no, that's no longer sufficient. So I just think there's been a sea change in how it's done. And there's been more than a sea change in the composition of the court. And they have the votes. And apparently Roberts doesn't give a damn about institutionalism anymore. And Gorsuch was this term seemed to also veer hard right. And Brett Kavanaugh is supposedly the most, expansive executive power of all of them. And he has this law review article asking for a more specific statute, which never was enacted. So, I can't count the votes, but I just have a bad feeling.
I will just point out that when Brett Kavanaugh wrote that law review article, which I believe was published in the University of Minnesota Law Review, if memory serves, there was another speaker at that seminar, and Brett and this other speaker were the two keynote speakers at the University of Minnesota conference, and the other speaker was me. And so I remember that conference very well. All right, I just want to read the three statutes in question and be the little ray of sunshine here. And I'm going to offer Roger a bet. So the first relevant statute is 28 U.S.C. 510, entitled Delegation of Authority. The Attorney General may from time to time make such provisions as he considers appropriate, authorizing the performance by any other officer, employee, or agency of the Department of Justice of any function of the Attorney General. That is statute number one. That,
and of course, he wasn't in the AG's office.
Correct, but he was once he was hired, he was an employee of the Justice Department, and the Attorney General delegated to him the power to conduct this investigation. That's statute number 1. Statute number 2 is 28 USC 515, authority for legal proceedings. This one's a little bit more convoluted.
Gnarly.
What's that?
Gnarly.
Yeah. The Attorney General may, or any other officer of the Justice Department, or any attorney specially appointed by the Attorney General under law, may, when specifically directed by the Attorney General, conduct any kind of legal proceeding. And just in case you were wondering, the next phrase is civil or criminal, including grand jury proceedings and proceedings before magistrate judges, which United States attorneys are authorized by law to conduct, whether or not he is a resident of the district in which the proceedings are brought. So the first statute says the Attorney General can appoint such people as he may need, or can delegate to any employee anything that he needs done that's within his power. And the second statute says that person can litigate as necessary, including in criminal proceedings. Now, the third statute, which addresses, I think, Roger's specific point that these statutes don't give him the authority to appoint people. Fortunately, 533 says the Attorney General may appoint officials to detect and prosecute crimes against the United States, to assist in the protection of the person of the president, blah, 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 and 4, to conduct such other investigations regarding official matters under the control of the Department of Justice and the Department of State as may be directed by the Attorney General. And so I just want to say that when I put these 3 statutes together, I have a very hard time seeing, and I understand that one justice of the Supreme Court, i.e. Clarence Thomas, did this. I have a very hard time counting to 5 that 3 statutes that independently each seem to authorize the Justice Department, the Attorney General, to do what Merrick Garland did here, that's been done, many times since 1974, that has been specifically affirmed by the Supreme Court, albeit probably in dicta, maybe not, and that was done in the Walsh case by the very attorneys general who are now raising questions about its legality. And in that Walsh case was upheld by none other than Larry Silberman, may he rest in peace. He was a good friend and somebody who I liked a great deal, despite his being a wonderful maniac conservative. I loved that man. The same opinion where he struck down the independent counsel law, he specifically said, but Walsh is okay because of this statute. I just don't see it. And I agree that this may not be a good vehicle to get her removed, because she is, as we discussed the other day, acting pursuant to the invitation of a member of the Supreme Court. But I don't believe, and maybe I'm Lucy with the football, keep believing in the Supreme Court behaving like a court. I don't believe that this has legs. And so here's my proposal for a bet, Roger. I bet you lunch at a restaurant of the winner's choice with a tweeted selfie acknowledging, or in my case, threaded selfie of the two of us acknowledging defeat by the loser, that whatever the final disposition of this case, it will not be on this basis. And if Trump wins the election and dismisses the case and we never get resolution of it, then it is that is null and void.
Well, I will look forward to losing that bet, but I'll take it.
All right. Let us go then, you two and I, while the evening is spread out beneath the sky, to New York City, where the fallout from Trump v. United States has begun. Trump filed a brief asking the court, Justice Merchan, to dismiss the New York conviction. As you will recall, the sentencing was rightly put off by Justice Merchan in order to, in my view anyway, rightly put off to accommodate this briefing. And Roger, what does the brief argue and what do you make of it?
Well, I think it's substantial because everything is up in the air. It lists a large, to step back, the immunity opinion talks about official acts, some things being absolutely immune, some things being presumptively immune and maybe absolutely immune, that we'll find that out later. And then unofficial acts, you see, the president is still not above the law. You can prosecute him for unofficial acts, except you can't use any official acts for which he would be immune in the course of prosecuting him for the unofficial acts. And so there's a long list of arguable official acts. They aren't necessarily, I'm going to emphasize, official acts for which he would be immune, which I think is crucial. But there is a long litany of official acts, and some of them were introduced, even though the whole crime is unofficial. For example, and probably one of the most important, there was evidence about Hope Hicks's conversations with Trump in 2018 in the Oval Office when she was the White House communications director. And some newspaper articles are coming out, and Anna can correct me on the details, but at least one, I think one was a Wall Street Journal article and one might have been a New York Times article. And I can't remember if it came out that he reimbursed Michael Cohen or that Cohen did pay Stormy Daniels. But anyway, they're having a damage control conversation. And he says something like, well, it's better it's coming out now than if it had come out then before the election. That's a very important conversation. It was mentioned in the summation, hit hard. Honestly, when early in the case, and this could be important too, before the case started, there was a motion to dismiss on a lot of different grounds, and one was delay, and DA Bragg said, well, there was important stuff we didn't get until early 2023, including he listed 2 people that went before the grand jury. It's pretty clear one of them was Hope Hicks. So, this change, this was getting this allegedly may have been one of the things that tipped his decision to go forward with the case. So, and then there are other things. He filed a 278E form with the Office of Government Ethics that eventually sort of half confessed that he reimbursed the money. There were tweets that half confessed that he reimbursed the money. And then there was a pressure campaign. There were tweets as president where he was sort of praising Manafort for not breaking under the special counsel's pressure, and contrasting that to this scumbag, Michael Cohen. And if you ever need a good lawyer, don't go to Cohen. And he used Twitter as an official forum, certainly. So all of these create issues and potential problems. And so I think they can be rebutted in terms of, and I'll give somebody else a chance before explaining why. But there are problems. And it's also a problem. There's an issue about whether, when this original, I think when the Supreme Court took cert in the immunity case, Trump tried to delay the trial until after the ruling, and Justice Merchan refused. And part of the reason was, he says, well, you've waived this. You could have raised this earlier in the case and you didn't. So it's conceivable that he could grab onto waiver. I think it's not the way to go at this point. The other problem is that the Supreme Court puts such a focus on prior resolution through the courts of what's admissible and what isn't. And that didn't occur here. And so I think even if Merchan says, on balance, these are rebuttable, these are not the sorts of official acts for which he's immune, that would have to be appealed maybe before sentence. I think, I don't know, nobody knows really. And then one last thing, and it's particular to New York law, and I don't have the necessary knowledge, but New York does let you, before the case goes forward, you can ask the judge to examine the grand jury minutes and make sure that there was probable cause, sufficient evidence before the grand jury. And to some extent, and I don't know what it is, you can challenge illegally inadmissible evidence. I assume it's not a great extent because they didn't emphasize this in their brief. So maybe that's not a problem. But anyway, there's a lot of moving parts, and so that's where I am.
Anna, what did you make of the brief, and where are you?
So look, I actually think that this is among one of the better briefs that I've read from Trump's New York trial team. And I don't mean to say that I think the arguments are good in terms of the substance of them, but what they've done here is take the gift that the Supreme Court gave them and have really taken that and made a lot of it. And it says, I think, a lot about the Supreme Court's opinion in that they are able to stretch it to the extent that they have in this brief. But with that said, I mean, the opinion is just so opaque. It is so hard to even understand what its limits are, that is why they're able to do this. So I on the one hand, I think that it's actually a pretty decent brief from Trump's team, even though I don't agree with the substance. But I also just think it says a lot about how poor the Supreme Court's opinion was in offering guidance to lower courts, because I have no idea if what Trump's team has set out here is what the Supreme Court actually had in mind or not. It may very well be that John Roberts and 4 other members of the court could read this brief and say, yeah, all this is right. This is what needs to come out. On the issue of this argument that they make about the fact that this wasn't litigated before the trial. I actually have a question for the two of you that I'm curious about, because to me, the idea that there should be an interlocutory appeal, that goes to this question of the president shouldn't be burdened by pretrial litigation and all of that. And that's why you would want to have all of this adjudicated before there's a trial. Here, there's already been a trial. And am I wrong in thinking that even if the indictment is dismissed, he could still be re-indicted and retried after, or no? Because the judgment of conviction has not been entered.
So a couple things. I want to return to the waiver issue, but he could, assuming he were dismissed or reversed on appeal, he could be retried.
Yeah, so that's my working assumption, but that's why I think that it's not convincing to say this dismissal needs to happen because these issues should, because that's one of their arguments, that they are saying this should have been adjudicated before trial, and therefore that is an error that you can't it's not harmless, like it can't possibly be harmless because everything should have been tried or adjudicated before the trial. Well, then it's kind of like you are asking to be put through the burdens of litigation again. Like, why not just look at it and say, okay, this should have come out, and what would have the impact have been on the verdict? Do you see what I'm saying?
They're going to make the argument that it should be dismissed because he wasn't given the opportunity to deal with this before trial. But that's where the waiver is important. Did he ask for the opportunity to deal with this? Did he make an argument that this stuff should be excluded because of the privilege emanating from the immunity that he claimed? And we know he was aware of the issue because he was simultaneously litigating it in the New York court, ultimately in the Washington court, ultimately successfully. But the question is, how specifically did he raise the question, and at what stage of the proceeding?
Right. And I think that the waiver thing is separate from what I am discussing here, which has to do with this, even assuming that there was no waiver, they are making the argument that, all of this should have been adjudicated before trial. And so that is an independent basis to dismiss the charges. To me, that logic just doesn't make sense, because then you could be retried and the president would again have to go through the burdens of litigation. That just doesn't make sense. The point, though, with the waiver that you're discussing, so yes, Roger is right. There was this thing where they had an individual motion that they filed, but it was not timely. So Justice Merchan rejected that motion on timeliness grounds. But I think, Roger, correct me if I'm wrong, because they mentioned this in the motion. Justice Merchan had a moment where he said, well, we'll just deal with some of these individual immunity objections when the evidence comes in at trial. And they then say that they put, from the transcript in this motion, different times in which at trial they raised objections saying we objected this based on official acts immunity or whatever. And I don't think they did that with all of these different pieces of evidence that they raise in this motion. But I do believe that at least for some, including the Hope Hicks testimony, that at the moment of trial, when Justice Merchan said, let's deal with it as it comes in, then they were objecting. And so I don't think those things would have been waived.
Yeah. So, all right. So let's break this down then by category of thing. So it seems to me first of all, this is all dealt with in a single brief section of Roberts's opinion, in which he says not only can it not be charged, it can't be used as evidence, right? Because what he's charged with is actually something that happened in New York at Trump Tower with the falsification of records to cover up stuff that was all before he was president. And so the stuff that happens while he's president is all used as retroactive evidence of the conduct or evidence bearing on state of mind. And so it seems to me the evidence falls into three categories. And, those of you who've actually read the brief, please let me know if there's a fourth category. But one is tweets that he sent while he was president. The second is evidence from White House staff and others about how he managed signing personal checks when he was president. So there's both White House staff and Trump organization staff who testify about how he paid people while he was president. To the extent that there are Trump organization people, I don't think that's implicated, but because that's really how he ran his private business. But to the extent Madeleine Westerhout and others who were working for the White House are testifying about the workflow, that would be potentially implicated. And then the third category, which I think the only example is this Hope Hicks thing, is matters where he is engaged in discussions with White House staff about how to handle something that's come up. So the first question for either of you is, am I missing something? Is there some category of evidence that is not covered by those three categories that he's claiming immunity over?
Did you mention the disclosure to the Office of Government Ethics, that form that was raised?
That would fall into the Hope Hicks category. It's something that he's obliged to do as president. I guess it's not entirely clear how official it is, but it's an official OGE form. So yeah, let's put that in the Hope Hicks category.
So I think that there's also they also have another category, although I think this might fall under some of your other categories, but it's testimony about Trump's response to the FEC inquiries related to Cohen, for example. And it's kind of, about the communication. So I think it falls into your category of communications responses. That is the Hope Hicks testimony. Of course, they're responding to the Wall Street Journal and New York Times story, that kind of thing. But this is more about, what Trump's response was when the FEC was investigating various individuals related to this case. So there's one of the things that I will raise here, because it does kind of raise an interesting question related to core powers, is Cohen's testimony that Trump told him that the FEC inquiry would be taken care of by then Attorney General Jeff Sessions. Of course, the Supreme Court has said that, basically investigative work by the executive branch is very much within the kind of core powers of the president. However, whether this really falls into that, because it's not a communication between the attorney general and Trump, it's a communication between Trump and a third party, Michael Cohen. And so does that, a president making representations about what his Department of Justice might do, I'm not really sure how that fits with the Supreme Court's opinion. What do you guys think?
Well, I think with all of these cases, what we have to do is try to figure out what Justice Roberts is concerned about, and it's not easy.
Right.
And what he does seem to say is okay. He says in this footnote 3, but of course the prosecutor may point to the public record to show the fact that the president performed an official act. So if something, to me, it sounds like, certainly if I were the people I would say that, if it's a tweet, it's public, and if it's the OGE form, it's public, and what you can't do apparently is try to probe that official act. And this is where I don't know what he's talking about. And, he says allowing that sort of evidence would invite the jury to inspect the president's motivations and his official acts and to second guess their propriety. None of this stuff to me, clearly none of this stuff is core, I think. These are not, he's not exercising the pardon power. He's not ordering a drone attack on an American traitor who is recruiting troops to levy war against the United States. He's talking with his communications director about what to do about adverse publicity concerning a crime he committed before he took office. And so if I were now, obviously, that will, if the point of the decision is nothing, that we can't use anything that would make the president's life more difficult, well, okay, but we do have other Supreme Court rulings out there, like Clinton versus Paula Jones, and there they let him, they let a civil suit go forward during his term where he had to be deposed about his sex life. And that too is highly undermining for a president. And yet they didn't overrule that. So I am assuming that mere, embarrassment from unofficial acts is not something he's protected from. But what he does keep saying, Justice Roberts, is probing the official act is something you can't do. And, I just don't know where the lines are on that. Certainly, the prosecutors, they aren't exactly offering these statements of his for the truth of the matter stated. He's saying, he's making false exculpatory statements. He's making half confessions. And so, yes, they are saying it's not all true. And you do have to, it's a criminal case. You got to consider his state of mind. So at some point, I just don't know what Roberts was getting at.
Yeah. And Roger, really quickly, Ben, I'll just say on that example that I was giving about Cohen testifying about Trump saying that Jeff Sessions would take care of it. The reason it came into evidence is because the prosecution, it went to Michael Cohen's credibility in the sense that the prosecution was trying to build a narrative of why it was that Michael Cohen stayed in the fold for so long. And then eventually, after he entered his guilty pleas in his federal investigations, he then started, telling what he said is the truth about everything that happened. And so here, you're not introducing this statement to say, oh, the president really did want to use his authority to pardon Michael Cohen. You're kind of introducing it for a different purpose other than showing Trump's intent or corrupt purpose or anything like that. And so the question is, is Roberts drawing a distinction between those things? Because it's really not clear. It could be that what he has in mind is he's just saying you can't ask a jury to consider official acts when it goes to proving up any kind of intent or corrupt purpose, because then you're asking a jury to inquire into the motives of the official act. But, can you have a limiting instruction for other types of reasons for admitting evidence? It seems like based on the opinion, no, but it's really just unclear.
All right. So I want to try to imagine the government's brief here, which we have not yet seen. But it seems to me that the first argument with respect to all of these is going to be that this was not official conduct. This is in that third category of presidential activity, personal expression through Twitter, personal management of the emergence of personally damaging material about his pre-presidential conduct, that sort of thing. I don't think that's a winning argument on a lot of this stuff, honestly, because I think Trump's Twitter account is used for all kinds of official activity. I think it probably is official activity in some sense. But for certain aspects of it, it may be correct. So they'll clearly try to lop this stuff off as not subject to immunity at all. Secondly, and maybe beforehand, they will argue that a bunch of this stuff is waived. And what is preserved, that's going to be a super technical question about when when objections were and were not made. Third, they're going to make a whole bunch of footnote 3 arguments. And the footnote 3 argument, as Roger suggested, is going to cover, and this I think is a winning argument about the tweets, at least, which is Roberts clearly says that the public record of the official act is admissible. He's not thinking about tweets when he writes that. He's thinking about pardons. But a tweet, like a pardon, creates a public record. And he clearly says that the public record of the official act is admissible. And so I think the government will say, assuming arguendo that this is an official act, it's an official act that creates its own public record. We're not looking behind the tweet. We're not saying what's the deliberative process that led to the tweet. We're admitting the tweet. That solves most, and by the way, the same is true of the OGE report. To the extent that's a personal financial disclosure required of the president, maybe it is an official act, maybe it's not an official act, but it doesn't matter because it creates its own public record. The public record is admissible. That's all we admitted. And by the way, we talked to the private sector employee of the Trump organization who produced that record. That is not a problem. And so you are left with, so I think all that stuff one way or another comes in and is going to be okay. The exception is the Hope Hicks testimony. And there I think the government has a real problem because this is the president consulting with his top communications officer about how to respond as president to something that arose in the context of, yes, his personal life, but he's now trying to deal with it as president. And I don't see how this isn't official. They'll argue that it isn't official, but I think the president consulting with communications staff about presidential communications is going to be found to be official, if not by Justice Merchan, then by the US Supreme Court on direct appeal. And so the question then becomes, assuming everything else comes in, and I think it does, is if you exclude her testimony and you say that shouldn't have come in, is that alone enough to void the conviction? And, that becomes a prejudice question, right? How prominent was this in a 5-hour summation? Was it me? I gotta say, as somebody who sat through that trial, the Hope Hicks testimony was a holy shit moment. It was not merely cumulative. It was a, oh my God. And by the way, in the summation, Mr. Steinglass, I believe, talks about how she said this thing and then burst into tears, right? It's a moment in the trial. And I don't really see how they treat it. I could see you're treating it as cumulative. Like, it strikes me as a little bit of a stretch to call it harmless error. And I do think the question of whether there was an objection in real time on this basis is probably super important, because one way you could make this go away as the government is to say, hey, they were litigating this in another court and we put her on the stand and they didn't object on this basis. You don't get to do that in retrospect. And so how exactly it plays out, I don't know. I do think the issue is substantial, and it almost guarantees federal court review of this at the end of the day, which I don't think was guaranteed beforehand. I do think the tweets are likely not to be error. The Hope Hicks testimony, I don't see how that's not a problem for the government. Do either of you disagree?
Yeah, I agree that it can't be harmless error, given how close the trial was, given how important the moment was. If that's an official act that would be immune, I think you need to retry the case.
I mean,
how would the government? Okay, let's assume it's an official act. How do you rebut the presumption? Or I think you raised this earlier, Roger, but with the Hope Hicks testimony, how do you rebut the presumption that there will be that there would be a danger of intrusion on the executive office?
Here's the government's best argument on this, I think. It would go something like this. First of all, it's not an official act. Hope Hicks was advising Donald Trump on how to respond on this very issue before he became president. It was not official then. It doesn't become official. That you had sex with the porn star doesn't become an official matter with your communications advisor simply because you become president. It was a personal matter before you became president. It remained a personal matter after you became president. Number two, to the extent that it is official and the court holds that it is official, it does not encumber the executive use of reasonable communications authority or the ability to consult with staff to say that when you are using your official staff for personal communications matters that began, that grew out of your pre-presidential Paula Jones-like conduct, just as we did not say that Monica Lewinsky could not testify about what was going on in the White House because it was all, official. We said the litigation could go forward because it was unofficial conduct because of Paula Jones, and then the chips fall where they may. Just as we did that, you don't get to use your it doesn't cause a problem for the executive's ability to communicate about executive branch business to insulate this. And then third, this whole argument works better if you can say, and it's waived anyway. But I don't know if they can say that. Roger, what have I missed?
My impression, and you all were there, but my impression is that after cert was granted in Fisher, not Fisher, in the immunity case, they got very good about objecting about this stuff. So unless the original waiver way back when waives everything, which I don't think it does, I think that's not going to get us out of this. That won't get him out, the government out, the people out of this predicament. And I agree with you. I think this is the toughest one. And the argument would have to be that something like, I also don't buy the fact that she gave him this sort of advice when she worked for Trump Organization, so it doesn't count when he's working as the White House communications director. It's a different thing. And so this is a recurring situation presidents have. They're confronted with something ugly in their past. Let's discuss the press impact. What do we do? And I guess my question would be, how does this chill, or the thing Roberts wants? The president needs to be act boldly and decisively and without undue caution in executive acts. How does this prevent him from doing that? This may be embarrassing, just like Paula Jones stuff. Clinton was the deposition, the interrogatories were like, name every woman, not your wife, that you had sex with for the past 10 years. That's while he's president. He's being asked these questions and they're being leaked. I mean, that's a lot of disruption.
No, Roger, it's way worse than that, because that's merely, he's asked the questions at his deposition of how he was managing White House staff. People like, at the grand jury, when he testifies before the grand jury, he's asked about his interactions with his secretary, Betty Curry, how she was moving, how Secret Service people are moving around, right? He's asked actually about core preclusive executive authority stuff. I suppose the justification for that, other than that nobody had thought of presidential immunity as a defense, is that, it's all evidence in a civil context that bears on pre-presidential sexual. But if you apply that, why can't your communications with your communications advisor, which also, by the way, came up with Clinton, right? His consultation with Dick Morris about, run a poll for me on this. Remember that stuff? And his communications with other people about how to manage the Monica Lewinsky situation should be exactly parallel here. And nobody, I covered that stuff. I was the Washington Post editorial writer on this for the entire time. Nobody argued that this couldn't be evidence in a criminal matter, but there was a grand jury. All these people are hauled in front of it because you couldn't look behind the president's conduct for use in evidence in a non-covered matter, i.e. the Paula Jones litigation. And so, sorry, I interrupted you.
Well, I think for all of these questions, the people will be arguing, we're not probing the official act, we're probing the unofficial act. And that's what these conversations she was on the job, he was on the job, but they were talking about unofficial acts. And they were going, and it's relevant to going behind the unofficial acts, and nobody is asking the jury to probe any official act. And I think that will be the people's mantra.
All right, we're going to go to audience questions. But before we go to audience questions, we actually have to answer a staff question. Many of you guys don't know this, but the Trials and Tribulations podcasts are edited by a combination of Jen Patja and a wonderful gentleman named Noam Osband, who works for Goat Rodeo. And Noam wrote me an email the other day that says, he's a political junkie, but until he started editing Trials and Tribulations, he had never heard of a writ of mandamus. And we throw around this term, writ of mandamus, like everybody should know what it is. But he promises me that that's not true. And so he posed the questions, and I'm going to give it to Roger. What the fuck is a writ of mandamus, and what are the mechanics of how it works? So we're all going to now comment on the writ of mandamus. Roger, what do you know about the history of the writ, what a writ of mandamus is, and the mechanics of how it works?
So, very roughly, at common law, meaning before the United States existed, there were these things called writs of mandamus. And after the U.S. Was formed, there's a statute called the All Writs Act that gives the Supreme Court and the courts of appeals this power to issue, among other things, writs of mandamus. And actually, district courts also have this right, but with respect to people that aren't judges. The way it works is that, to appeal something, and you all now know the term interlocutory appeal. You can only take, ordinarily in a criminal case, for example, you wait till the very end. If you're convicted, you appeal everything all at once. You were upset about some pretrial rulings. You were upset about evidentiary ruling. You appeal them all at once. It's inefficient to keep going up and down every time there's a dispute. So to take an interlocutory appeal, the statutes are very specific. You can only do that for X, Y, and Z. Then there are these emergency situations where, the claim is the judge has really, it's not just that she got it wrong, it's that she abused her discretion in a egregious way, and I need it addressed right now, and waiting for appeal afterwards isn't going to solve the problem. And then you can take a writ of mandamus. So that's basically my take on the writ of mandamus.
Anna, do you have writ of mandamus thoughts?
I have no writ of mandamus thoughts other than I will add that the writ of mandamus, some scholars trace it back to its origins, back to the 13th century. And it was a writ that was developed in the Court of King's Bench, which is a court that initially was this court that kind of was the king's justice. They traveled around with the king wherever he went and would kind of deal out decisions. And then eventually it became a court that kind of stayed in one place. And it was distinct from the courts of chancery, which were the courts of equity. And we've talked on this podcast previously about the distinction between at equity and at law. And so I don't know which podcast episode that was, but you can go back and listen to that one. But that is all that I have to add in terms of random knowledge about writs of mandamus.
All right. I will add one fact about writs of mandamus, and then I will tell you a writ of mandamus bedtime story, even though it's not bedtime. But I have a great
bedtime.
I have a great writ of mandamus story, and it's not often that people ask you for information about writs of mandamus, and you get to tell your writ of mandamus story. But first, the core of the writ of mandamus is the idea that some official is not doing his or her job, and you go to a court and you ask the court to issue a writ mandating that person do his or her job. Usually it shows up now, as Roger describes, as a form of appeal that's a kind of an extraordinary relief, right? You can't wait for the regular order to appeal this for one reason or another, but Judge so-and-so did such an awful thing that you're asking the Court of Appeals in an extraordinary way to issue a writ saying, Judge Eileen Cannon, do your job as the law requires you. You are mandated to do that. That's really the essence of the writ. Somebody is not doing their job. You order them, you get a court to order them to do it. For that reason, it is a disfavored remedy. Normally, there's a normal way to get somebody to do their job, and you have to really show that there's an extraordinary abuse going on. Which brings me to my writ of mandamus story. I was a young reporter for Legal Times working for the same organization that Roger Parloff, who was the great features writer at our parent organization, the American Lawyer magazine. And I went to one of my first ever DC Circuit hearings. And it was Larry Klayman arguing for a writ of mandamus in front of a panel that included Judge David Tatel, the great liberal judge, and Judge Harry Edwards, who was then, I believe, the chief judge of the court at the time. And Judge Edwards he's an extraordinarily bright man and extremely irascible. And he was a very tough person to argue in front of. And Larry Klayman, for those of you who don't know him, he founded Judicial Watch. He was a right-wing provocateur and not an unintelligent man. He was extremely litigious, which is why I'm being careful with my words. At one point sued his mother, which was just one of those things that happens, I guess, in the Klayman family, and was in front of the panel asking for a writ of mandamus about something that some lower court judge had done. And I don't remember what the issue was. I just remember the show that, and Larry Klayman gets up and he is on best behavior. He's a smart man, and he's not he's a kind of unusual right-wing ideologue. He was a fairly capable lawyer at that point, and got some interesting things done in that period of time. And Judge Tatel, who is a very gentle man, said to him, but mandamus is a disfavored remedy. And, why is this? And he says, and there's this big show of politeness. Judge Tatel hits the nail right on the head. Of course, it's a disfavored remedy and blah, blah, blah. And, but we think we've made a showing. And this goes on for some time. And finally, Judge Tatel says to him something along the lines of, so I see your point. I see the argument that you're making, but I'm just not sure that this court at this stage of the litigation has anything that we can do about it. And something in Klayman just snaps. And he goes, are you telling me, Judge, that Janet Reno can murder innocent children and women at Waco, Texas, and this court is powerless to do anything about it? And Chief Judge Edwards throws his hands in the air and says, and you were doing so well. And it was the best moment I had ever seen in court. And it made there was an uproarious laughter among everybody in the court. And years later, like 20 years later, I am at dinner at the home of a Justice Department lawyer who will go unnamed. And I start telling this story. And she goes, oh my God, were you there? I was there. And you were doing so well. And we had a real laugh over it. It made a huge impression on everybody who was there. So that is my writ of mandamus story. I'm going to, we're going to go to audience questions. Going to try to get through as many of them as I can. We got a lot of them.
Really quickly, just because we need to do our due diligence with this being Trump Trials and Tribulations and get all the updates out there before we go to audience questions. I do have a Fulton County update. This week, the Appeals Court of Georgia decided that they would grant oral argument for the Trump appeal that is seeking disqualification of Fulton County District Attorney Fani Willis. That oral argument is set for the first week of December. So that case, it was already certain that that case was not going anywhere before the election, but it is actually not going to have anything decided, it seems, before December. At least we expect that a decision from the Georgia Court of Appeals will come down probably in spring of 2025. So that's a little update there. And then also the Justice Department the government did file its notice of appeal of the dismissal by Judge Cannon in the documents case that happened yesterday. We already knew they were going to appeal, or assumed that they were, and had a statement from Peter Carr from the special counsel's office that there was authorization to do so, but that notice of appeal was not filed until Wednesday. So those are just two little updates that I think were important to get out there before we move to audience questions.
All right. Kevin, the floor is yours.
Hi. I just wanted to ask, are there any prohibitions on Judge Cannon coordinating or communicating privately with Supreme Court members, either directly or indirectly, about the Florida case?
So I do not, well, as a general matter, it is perfectly kosher for Judge Cannon to consult with her peers on her own court, which she has apparently refused to do. It is very unkosher to discuss a pending matter with a member of a reviewing court. Is that a fair summary, Roger?
I hope that's true, but I don't know if that's true. And nobody could enforce it if it were true or weren't. Nobody can enforce anything against the Supreme Court, as we've seen.
Also,
right.
I mean, why would you need to communicate with a Supreme Court justice when there are Supreme Court justices who will just write a concurring opinion that says whatever they want you to do?
Yes, I mean, I think the mode of communication in the Supreme Court to Cannon direction is very public, actually. All right, a question submitted in advance. Last week, Lawfare published an article suggesting cautious optimism that the military would disobey an unlawful order. Given your unanimous agreement that the presidential immunity ruling lacks constitutional support, I'm curious about the following. 1, would you support district and appellate courts who refuse to comply with this ruling based on the lack of constitutional grounding and unworkability? 2, what forms of civil disobedience could lower court judges engage in to undermine or disregard the ruling? 3, wouldn't a widespread refusal to comply with this ruling create immense pressure on the Supreme Court to reconsider or walk back their decision? Can you draw parallels to historical instances like Furman v. Georgia, where significant backlash led to changes in the court's stance? To me, this ruling necessitates a constitutional crisis, but I'm not a lawyer, and I look forward to Ben and everyone else logically ripping apart the premise of my question. I'd love an article on the subject. Thank you. So I will answer this question only for myself. I think the only people in the world who are precluded from engaging in civil disobedience is judges. And I would never encourage a judge under any circumstance to engage in civil disobedience. I think if you don't think you can apply the law consistent with your, and I say that as somebody who regularly engages in civil disobedience, in fact, plans to do so tonight. I'm going to dump a very large quantity of marking chalk on the street in front of the Russian embassy. I don't think I'll get arrested, but Don't think it violates any laws, but in the event that it does, I'll pay whatever fine is appropriate. I don't think judges get to behave that way. Judges are creatures of the law, and for judges to engage in civil disobedience defies the essence of the project. And I think, speaking for myself, if you're confronted as a judge with law you cannot in good faith and good conscience apply, the proper response is recusal or resignation. It is not to knowingly defy the law. Supreme Court decisions are binding on lower courts, and to me, that's the end of the story. I'm a hardliner on this. Roger and Anna, do either of you want to make a case for judicial resistance?
No, I'll pass.
Well, I mean, look, I think that there are ways to do judicial resistance that is still within, like, interpreting a really opaque opinion in a very narrowly in a very narrow way. Like, there are ways to remain within the law without getting to a point where you are refusing to apply the law and that kind of thing. So I will just say that. But Ben, Ben, I think I need to think about it a little bit, but I think I agree with you, Ben, that if you get to a point where you cannot faithfully, as a judge, that you cannot faithfully apply the law, you are at a point where you need to quit your job. And that might be because of your moral conscience tells you that you must. It might be for other reasons, but I think that I might agree with you, Ben. I just need to think about it a little bit more. But it's an interesting question.
By the way, I also think that other people are free to engage in civil disobedience with respect to this opinion. I'm not sure.
Yeah, and I agree with that too.
And I love the fact that the current president seems to be entertaining proposing a constitutional amendment to overturn it, although I'm not sure that has any likelihood or prospect of success, at least not in the short term. I just don't think judges can ever engage in civil disobedience. Carl, the floor is yours.
What remedies are there for overturning, narrowing the decision? I can only think of constitutional amendment, which I doubt is going to happen, or a future Supreme Court taking up a set of cases that lets them overturn the existing decision. Anything else out there?
Constitutional amendment and the actuarial tables seem to me the only remedies here. Anything else, Roger? Anna?
You would need, a landslide victory for the Democratic candidate and all of the candidates beneath him, followed by appointment of additional Supreme Court justices, and then you could something could happen.
I'm not sure that's right, because you can send a constitutional amendment to the states with simple majority. It's not. I think the problem is the state legislatures.
I'm talking about appointing additional judges. That doesn't require a constitutional amendment.
Gotcha.
It does require controlling both houses and the presidency.
All right. Question submitted in advance. There is one thing I don't understand about the immunity decision. I will add that that's one. There's only one thing you don't understand about it, you're way ahead of me. Legal observers, you guys included, concluded that certain evidence in the hush money case in New York was probably privileged or otherwise not admissible. Trump's legal team is using that argument to petition to vacate the conviction. I think the opinion was kind of novel in its interpretation of presidential immunity. So in my mind, realistically, the New York court could not have foreseen that certain evidence or testimony would be verboten. how can an opinion like that basically apply retroactively? And in general, should and could this apply to other decisions? Like the court decides something is new and changed, and the courts would have them go back through all the verdicts that have been rendered and throw stuff out. It just seems nuts to me. I'm not a lawyer. So I'm not a lawyer either, though I play one on TV. So first of all, remember that the conviction in the New York case is not final. It is not final until sentence is issued, and that hasn't happened yet. And so this is not though it looks from the outside because there's a jury verdict, it's not a situation where there's some old stale conviction that is called into question by new law. It's a situation where a pending case is called into question by new law. So that's the first point. The second point is this exact issue is why the waiver question is important. Because the question is a different one if they've been saying all along, we object on this basis, we object on this basis, we object on this basis, while they're litigating this issue in another court. Then the court says, Emile Bovey, you're right, and Todd Blanche, you're right. Then it's kind of legit for them to come into court and say, see, we told you. If they haven't been preserving the issue carefully, though, it's a bit of a different question, because then it's kind of like, as you say, they've just won the lottery. And but then finally, there are these cases where you just win the lottery. Somebody else makes the argument, and this is what's going on in some of the Fisher cases, where the Supreme Court later says, hey, the matter in which you were convicted was based on a misinterpretation of the law. And there are circumstances in which you get to reopen your case under those circumstances. They're not all the time, but there are circumstances in which you do that. All right. Anna has had to drop off. We're going to take a few more questions and then call it a day. John Hawkinson, the floor is yours.
Thanks, Ben. This is a silly question. So what, if anything, do you make of DOJ's delay in noticing its appeal until Wednesday, given that the special counsel spokesman publicly stated that the department, presumably the Solicitor General, had authorized the appeal on Monday? Is it at all plausible that DOJ was considering Randall Eliason's argument that they should re-indict in SDFL through the U.S. Attorney without appealing? And there's a link I'll put in the chat. And that it took them 2 days to decide not to do that?
Roger, do you have thoughts on this? And by the way, John, that is a really silly question. Shame on you for asking it.
No, it's not a silly question, but I mean, Peter Carr wouldn't have made a statement. He said he was going to appeal, so I don't think he would have made that statement if they were still wondering, what should we do? What should we do? And they had 30 days to appeal, to file the notice of appeal, and they filed it on day 2. So that's pretty prompt. It's unusually prompt. I wouldn't make too much of it.
Yeah, I will also say it's not a 2-day delay. It's a 1-day delay, because Peter Carr made that statement at the end of the day on Monday, and they filed it on Wednesday. So they really only missed Tuesday. As notices of appeal goes, that's really fast. All right. Matt, the floor is yours.
So in the Florida case, does Jack Smith still have a colorable argument at this point that the 11th Circuit should expedite this appeal? Maybe it's a long shot, but given how fast they handled the case last time in the civil case, granted there was a different posture of the case at the time, maybe the reason for that, but I'm still wondering if that's still an argument he can reasonably make or not. That's all.
What do you think, Roger?
That's a good question. It's a question that affects both cases. I think there's a case to be made that it's just because it's two cases, and it no longer looks to anyone like election interference. It's not going to, it's an appeal. We're just getting the law straight, but we need to know relatively quickly, whether these things are still in kosher. And so the special counsels. So I think there's an argument to be made. What do you think, Ben?
I think they will likely ask. And I think, look, the 11th Circuit is not an it, it's a they. There are different panels of the 11th Circuit that could have very different prudential instincts here. One of them, I think it's perfectly plausible to imagine a panel that will be deeply embarrassed by Judge Cannon and will want to deal with this promptly and decisively. And by the way, this is not an ideological point at all. This was the instinct of the last panel, which opinion, if I remember, was written by Judge Pryor, who is, somebody who Trump could plausibly put on the Supreme Court if he doesn't put Judge Cannon on the Supreme Court. And so, some of this stuff is just really offensive as a matter of judicial craft. And she has been embarrassing that circuit for, a couple of years now. And there may be an internal instinct to deal with it quickly, simply by way of sending a statement that this is not who we are. I don't think there's any real reason to expedite it other than that, honestly, at this point. There's no way this is getting tried before the election or in any, timely manner. So the issue is handling it well at this point. But handling it well may also involve handling it decisively and quickly. So I don't think it's an obvious case for expediting, but I don't think it's it wouldn't surprise me either. We are going to leave it there. Folks, in the YouTube community, don't you wish you'd gotten your question answered today, whether it was about a writ of mandamus or about expediting cases? You should come into the light, become a material supporter of Lawfare, join us in the inner circle conversation, get your questions answered, have your voice go out to, tens of thousands of listeners of the Lawfare podcast, posing immeasurably intelligent questions. You want to. So go to lawfaremedia.org/support and become a material supporter of Lawfare. You will be glad you did it, I promise. Everybody writes me all the time. People come up to me on the street and they say, "Sir, I am so glad I became a material supporter of Lawfare." With tears in their eyes, they tell me this. No, that has literally never happened. But if I were Trump, that's what I would say. Look, we're going to be back next week because one thing I can promise is that the Trump trials and tribulations will not stop trialing and tribulating, and we will be here when they do. Thanks to you all. Thanks to Anna, and thanks to Roger. We'll see you soon.